Garrett. I'm a venture associate with Ideaship, and today I'm sitting down with Leif and Jim to discuss patent law for startups. Leif is the founder and CEO of Retrolux, which is a Ideaship investee company, and Jim is a shareholder at RQN, which is a law firm that we at Ideaship work with quite frequently. Ideaship is a patent equity fund that supports early stage entrepreneurs through directed patent capital as well as in-kind strategic patent services. Essentially, we act as your ad hoc patent department and guide you through harvesting and filing on your innovations and leveraging that work to help stimulate fundraising and acquisition. Leif, I'll hand it off to you to tell us a little bit about Retrolux.
Yeah, sure. Happy to share a little bit about Retrolux. So we're a software company that builds tools for contractors to upgrade existing commercial buildings with energy efficient and smart technologies like LEDs, HVAC improvements, and plug load management. Our software is end-to-end, supports the entire project lifecycle, and focuses on collaboration between those contractors and their suppliers and the building owners themselves. Ultimately, that allows us to scale what I learned as an engineer and entrepreneur doing energy efficiency projects so that we can really meet the impact and sustainability goals that we've set as a company to help keep fossil fuels in the ground, which is really important to me and is one of my passions. So we're really excited to be an Ideaship fund company. They've done a great job of helping us protect our IP, think about it more holistically, and just really excited to be part of the program today.
Thanks, Leif.
Yeah, my name is, I'm Jim Below. I'm a shareholder at a law firm in Salt Lake City, Utah. I've been practicing law for about 10 years. Before that, I studied electrical engineering before going to law school. And you know, I've kind of, my practice has kind of morphed into writing patents and acquiring patents for various software companies. I've worked for really big companies like Microsoft and Facebook and Dropbox, to startup companies, and even some startup companies that have kind of become big, like Qualtrics and Tile, some companies that have some pretty cool products that you probably see every day. I think my favorite part of the job is meeting with inventors and kind of getting back to my engineering roots and talking about the technology. And then while I do enjoy the law aspect, I do think the technology is the coolest part. So.
Absolutely. And honestly, that's one thing I love about patents. I was a software developer in my past life, and it's a great way for me to be able to revert back into the technical weeds of it all. Before we get started today, it's important to note that while we'll be weighing in on issues regarding patents and startups, all comments from myself and our two panelists today are representative of their personal opinions and are not reflective of their organizations. Additionally, everything said today is not legal advice and it does not constitute legal advice. Having said that, we can hop right in. So to kick things off, Jim, to really start at the beginning here, when you're approached by a startup that is interested in pursuing patent protection, how do you best determine whether or not they should pursue that protection? Because obviously it's a very expensive and time-consuming process.
Well, I mean, I guess the first step is to determine if they have a patentable idea, right? Like, and you don't need to get into really the weeds of what they're doing exactly. But if someone comes to you and says, hey, I want to start a new dog grooming business, I want to get a patent for that. You're like, well, it's probably not a patentable process. But if someone comes to you and says, hey, we've made an improvement to internet technology, or we've, created a new way to store power on a battery or something like that, then it's pretty obvious, like, hey, you probably have a patentable invention. Let's talk about it. But I think it's important to really kind of help them understand the rights that they're getting when they file a patent. So for example, what a patent gives you is the right to exclude other people from making and using your invention, at least as it's described in the patent document or as claimed in the patent document at the end of the document. And so you have to kind of help them understand that it's not a right to use their invention. It doesn't protect them from other people who have already patented the invention. It's just a right to exclude others from making and using their specific invention. And then you kind of have to figure out why they want to file a patent. Like, are you trying to make money off of it? Are you doing this as an insurance policy? Are you doing this to license it? Are you trying to sell your company? Because there's all kinds of ways you can monetize a patent. And I think those are kind of the four. You can sue someone and try and enforce it, which is, I think, the most difficult path, albeit potentially the most profitable. We've heard about $100 million cases from big companies suing other big companies over a single patent. That's pretty rare, and it's really, really difficult. The second is, licensing your technology, which is pretty common and a little bit easier, although it does require some sophistication to kind of navigate. Third is using it as like an insurance policy to prevent people from infringing on your product, like potential competitors or a big company from swooping in and stealing your idea. And then the fourth one is just create, and all of these can kind of be done concurrently. Like, you don't need to pick one. But the fourth one is kind of acquiring assets that can be valued and then sold. Either the patents themselves can be sold or just add value to your company in the event that you get acquired. So I have to talk to the inventors about that. And then I talk to them about budgets, because patents are expensive. And if you can pay for it, you need to be willing to kind of pay $10,000 to $15,000 up front just to apply for a patent, not to mention the prosecution of that patent. And so sometimes you talk about funding opportunities, or if they have the money. And a lot of times, I've noticed that a lot of inventors are relatively wealthy people who are kind of like bored. And so sometimes they have the money, but more often than not, it's usually people that just have a good idea, that are trying to start their own business, and maybe they're a little strapped for cash, and so you do have to walk them through that and kind of brace them for the impact. But you have to just be as upfront as possible to let people know what they're getting into.
Absolutely. Leif, I'd be interested to hear about when you started considering patent protection. What did that journey look like for you, from that being an idea to actually taking the steps necessary to secure patent protection and building out a patent strategy?
Yeah, sure. So I came up with the idea for Retrolux, like the core idea, in 2011. And I went through an accelerator called the Clean Tech Open Accelerator in 2012. And they covered all facets of business, startup business in particular, obviously. And one of the areas they talked about was IP. And so that was the first time I thought about intellectual property and specifically patents for Retrolux. And I remember a really prominent patent attorney in my hometown sharing that all a patent does is it gives you the right to defend it. And if you can't afford to defend it, you probably shouldn't be filing for a patent. And, this is a very broad blanket statement. It doesn't get into the weeds of why you might want to patent it, but it really stuck with me, because I think it helped me realize that a patent is not magical. Like, it's not this magical thing that will turn your business into gold. It really is a tool to help build value for your business within very specific guidelines. And so we looked at what we had for funding as a company. We said, that's not the biggest thing we should spend our money on right now. We don't have the money to defend it anyways. And our idea is still not as developed as it could be. And so we had all these reasons why it wasn't the area to spend our energy and our money, our limited resources. So we didn't. We instead focused on other things like making sure all of our team members signed assignments of invention to the company. So anything they built was owned by the company, making sure we protected our brand, signing NDAs. Like, we did a lot of things to protect the assets of the company, but didn't do a patent. I also did a lot of research into patentability of software. Can you patent software, and how easy is it to get around software? And I always told people, if Apple can't get away with patenting the iPhone, how easy is it going to be for you to defend your patent of whatever it is to much smaller companies? And so these are things I thought about as I kind of justified delaying working on the patent as long as we did. And, there's other things in there, but mostly it was a prioritization. There was more important things to work on. And more important things to spend our money on than patents. And just here in the last 2 years, we started getting more serious about patenting our work. And it wasn't so much because we finally had the resources and we finally had the time to do it. It was more so because we had finally crystallized our ideas and found white space in our industry that we thought was super valuable. So our early ideas are like a small piece of what is now going to be what we're patenting and what we have worked to patent. But our thinking and sophistication had evolved to the point where we identified significant white space in our industry that we could file foundational patents on, and we wanted to get them done before anybody else did. And so it was a timing issue. It was we finally know enough to be smart issue. And so even at that point, we were still hesitant to spend the resources. And fortunately, I had a relationship with Robert Bell, who's with Ideaship, and when he joined that organization, came to me and said, "Hey, we've got a program to help companies with getting their innovations protected. Are you interested?" And we said, "Sure." Learn more about the program, and ultimately, we're able to secure an in-kind investment from Ideaship that helped us get our innovations cataloged, valued, roadmap on how we should protect them, and then ultimately help support us in getting our first 2 patents filed. And if they hadn't done that, I still don't know if we would have gotten a patent filed, to be honest, because we just had other things that we could focus on. We weren't experts in IP, and we didn't have that skill set. And so, it was easy to defer that to another day. Ideaship, definitely gave us that head start and helped us do a great job. But ultimately, the biggest lift they gave us was making sure we had, best in class patent counsel to help us with turning my ideas into something that can be protected and defended. Because again, a patent just gives you a right to defend. And so they need to develop that patent in the legalese that other lawyers will understand. And if everything did go to where you had to defend it, it would actually be enforceable. So, that process from when we engaged Ideaship until our first non-provisional patent was filed was about 9 months. The second provisional patent that we filed, or the second patent, which was a provisional, took another 3 months, 3.5 months. So, from the time I had an idea to the time we had our first patent filed was 10 years. And so the second one, 10 years and 3 months. And the total cost was about 20 grand, just for the lawyers, not including all the additional support we got from Ideaship, which was another significant amount of money. So it was not cheap. We had to give away some of the company's equity to get it. Totally worth it. And even when we decided to push play, we got great legal counsel to support us, and it still took 9 to 12 months. So it's not a fast process. Then I found out it's going to take another 2 years before they actually finish the dang thing. So it's like 3 years, from beginning to end of having something you can go, put on your wall and wave around. So it's a long process. It takes a lot of time, but doing it with people that are good at that work is just like anything else. You wouldn't hire a kid that knows how to develop a website to do a super in-depth AI app. You're going to find a machine learning specialist. It's same thing with patents. It's a specialty type of law. You need experts, and I'm so glad we have them, because I can't even begin to imagine what our patent would have looked like if I had tried to barf what I have in my brain out onto the paper myself. So another thing that's also important on patents, just one quick note, is once you file a non-provisional patent in a certain amount of time, they're going to publish it. So if your idea is great, but you don't actually write your patent correctly, you've given away the keys of the car by publishing it, and everybody in the world can read it. So if it actually is valuable, but you didn't protect it properly, you've actually done yourself a huge disservice, because now people are going to be like, that's a great idea. I'm going to actually protect the right parts of it that they've missed. And then they may come after you for patent infringement. So, you've got to be careful to make sure that you're, actually protecting what you want to protect, because eventually it gets published, and that means the world knows what you've done. So.
Thank you, Leif. There's a lot in there, and I think there's some really key takeaways One being, as you said, it can be very difficult to properly prioritize patents in a way that you can actually execute on your strategy in time. In the early stage, in the United States at least, from the time that you publicly disclose your innovation, you have 1 year to actually file for protection on that. After that, you lose filing rights. And that 1 year is not a lot of time to raise the money necessary to actually build a patent strategy and execute on it, but also find the time and the manpower to sit down and put in the heavy lifting required to get to that point. And, to your point, the founder has so many other highly urgent, mission critical things that they're managing at any one given time, that having somebody who can help guide them through that process can be really beneficial. And it's really what we try to do at Ideaship, is essentially support our investees as their ad hoc patent departments. And I think your point around patent value is also a very important one. I've heard varying numbers, but the conservative estimate is that 95% of patents have no value. So, it can be very easy to have a patent granted, but to actually have a patent granted that will ultimately lead to some sort of return on the money that you spent on that patent is a lot more difficult. And, where it becomes so important to be working with experts. Sort of back to the original question here of, as a founder, should I file a patent? You made a really good point around the software side of things and how there's this perception around the patentability of software, particularly since the Alice ruling. And Jim, I know that you pretty much exclusively focus on software patents, and that's really your bread and butter. So I'm wondering if you'd be able to shed some light on your thoughts on the ability to patent software and how you think the Alice decision really shifted the playing field.
Oh my gosh, it shifted it a ton, right? I mean, so for those that aren't aware, what Alice is a Supreme Court case in which Justice Kennedy declared himself the expert of patent law and technology and decided to come up with a new test for determining whether software was patentable. And it actually wasn't even he came in and he said, like up until 2014, which is when the Alice case came out, you pretty much could say that a series of steps were performed by a processor. And as long as you tied it to a machine of some sort, then it was not considered an abstract idea, because abstract ideas or laws of nature aren't patentable. And so what happened in Alice is that the Supreme Court established a two-part test to determine whether a series of steps or a process is patentable. The first question you have to ask is it directed to an abstract idea? Can you give a ton of guidance on what that means? And if it's not an abstract idea, then it's patent eligible. But if it is an abstract idea, there's a second step, and that is, does the claim, when considered as a whole, does it recite significantly more than the abstract idea? And it's a super nebulous, super subjective test, and the Supreme Court struck down the patent that was being considered. And that was really all the guidance that the Federal Circuit got and that the Patent Office got for like 2 years. And so the Patent Office pretty much stopped allowing patents for about 2 years, like stopped allowing software patents. From 2014 to 2016, I thought I was probably going to retire and start a new profession because nothing was getting allowed. I was working for Facebook at the time, and they were talking all about their targeted marketing stuff. And that was all under the definition of Alice, an abstract idea. But what has happened since 2016 is the Federal Circuit, which is the court just below the Supreme Court, has started, they obviously were getting a lot of stuff appealed to them saying, hey, this is obviously a patentable idea. Please reevaluate this. And everyone's begging the Supreme Court to revisit it and come up with better guidance. But what the Federal Circuit did in 2016 is it reviewed a couple of cases. One of them was called the Enfish versus Microsoft, and the second one was called McRow versus Bandai. And what those cases decided, and it kind of gave a little bit more guidance on what an abstract idea is or isn't. And it said that an idea is not an abstract idea if it is directed to a specific improvement in computer functionality. So if you're dealing with like a purely internet-centric problem, or like you're saving network bandwidth, or you're saving storage space, or in some cases you may be just improving the user experience via like mobile device technology, then that would be no longer considered an abstract idea. And then the McRow case, it just kind of includes an additional requirement that the actual claim that you're making has to at least recite some technical details that relate to the technical problem that you're solving. So what the end result has been is that claims have gotten a little bit more detailed related to the specific technology that you're trying to patent. So you don't see like these nebulous, like 4 steps that could read on the entire internet anymore. You're seeing a little bit more narrowly tailored claims that are directed to solving a specific technical problem. And ever since 2016, it's been getting better. I think patents are getting more and more, are getting allowed much more frequently now than they were then. And even in 2019, there was some new guidance that the PTO released that made it really easy for patents to get allowed on software. And there's still some tension between the courts and the patent office, but overall, I have to say it's almost a non-issue if you are like thinking in advance, what's the problem I'm solving? What are the features of my invention that actually solve those problems? And as long as you include those in the patent, you're probably going to be getting a patent directed to like at least eligible subject matter, as long as it hasn't been already invented by someone else. So I would say as of 2019, patents in software are pretty easy to get, at least compared to before 2014. But there was like this 5-year period where, holy crap, like I'll bet you half the patent attorneys quit and just stopped practicing altogether. And there's a reason why a lot of software companies have stopped applying for patents up until recently. So.
And, I think that that's the perfect overview of sort of what we've been seeing since the ruling is the strictness around allowability has been backing off a little bit. And, I think that this segues well into a little bit more of an opinion question that I think might be a little controversial, but I'm interested to hear both of your takes, is whether or not there should be software patents. A lot of larger companies have come out against software patents. Google's one of them. And oftentimes the argument is, well, it stifles innovation and they're all abstract processes. Why should anyone have any sort of patenting right? And I'm interested to hear your takes. I have an opinion, but Jim and Leif, what do you think about that?
So I'll take a stab at it. I think if we're going to allow patents in particular, then software patents have to exist. I think there's a strong argument to be made that no patents should exist in today's world. And I could get my head wrapped around that, but singling out software as being somehow unique in its behavior or its innovation potential is absurd. Software is innovating at a speed that is eons beyond products and or hardware, and so therefore that doesn't make any sense that you would single out software. The bigger question around should software or hardware or anything be patentable, I think is a good question. There's a lot of challenges with patent trolls and organizations, I think, putting too much into patents or protecting things that are too broad that do stifle innovation. But a lot of the patents that are getting filed are very specific to protect an innovative way of doing something that is unique to a particular business case. And I think there's value in protecting them so that people will spend the time and energy and research and development costs to develop that IP and commercialize it, knowing that they have a greater potential for profit. So if we're going to throw out patents, then we should just throw out patents and just be done with them. We shouldn't single out software. So at a high level, that's my view on it. Right now, it's the way the game is played. And so if you're going to be in the game, you got to play the game the way it's played.
I mean, I obviously have strong opinions. I mean, I'm a patent lawyer. I have a vested interest in patents being a healthy and higher valued asset, right? And I mean, the theory behind patents is that in exchange for you disclosing your invention, the government gives you up to a 20-year monopoly on the claimed invention. And I think that there are obviously should be some balances, right? Like you can't just claim super broad things that where your invention is like this little tiny part of it, but you get protection over everything under the sun. Like I think that patents should be targeted to specific innovations. And I think that would be good if we did a better job at that. But I do think that patents have done a remarkable job at incentivizing innovation. I mean, think of pharmaceutical companies, right? And how they like Bayer aspirin, like Bayer invented aspirin, right? And it wasn't Bayer, it was someone else, but that's the brand name. And they had that monopoly for 20 years and everybody wanted to sell this product. And the day after their 20-year term ended, you had like 12 generic brands on the shelf right next to them. And it was public domain. And I think that by forcing people to disclose their invention, you give people a blueprint to design around, which is by design. You want people to be able to design around and find improvements and stuff like that. I mean, obviously, I think patents are a very good thing for innovation. And I think that the large companies, you're right. I mean, Google doesn't want patents anymore because they already have cornered the market. And so you have these I think if you got a collection of the 20 largest companies in the world, they'd all say, yeah, let's do away with patents. They're not doing us any favors. We can just crush the competition by incorporating their products into our software. I think that patents are a really important tool, especially for small companies to protect themselves in case they get too big and then they get on the radar,
And, I really think that your point around enabling smaller players to actually penetrate a market is really my biggest thought of why patents are valuable. Ultimately, the patent system was designed to be a balance of incentives and controls. And even as it stands now, too often new players deal with more of the control side while larger, more established players enjoy more of the incentive side. And that's true. Due to resource allocation, larger corporations are able to throw millions of dollars at their patent portfolios versus as a startup, you have to be very strategic with every dollar spent, which is, again, why it's so important to bring experts into the fold and make sure that you're getting varying opinions from people, because the patent landscape is so complicated that no one really knows anything. And you, as a non-patent attorney, definitely want to make sure that you have a solid support team to supplement your understanding of your product, because ultimately you understand your technology better than anyone, but that doesn't necessarily mean that you're going to understand how that technology reads from a patent perspective. So I would tend to agree that patents are a good tool for evening the playing field, and I think that software is no exception there. And especially the scale at which software companies are able to grow and dominate the market versus what we've seen in more traditional industries is, in my opinion, even more reason why there needs to be that system of incentives and controls in place.
Yeah. So there are abuses of it, right? I mean,
yeah, absolutely.
You have companies that like the one-stop shop, like the one-click shop patent is. I mean, obviously there's more to it than that. But if a company really did try to get the idea of like a single click and then a whole bunch of actions based on that single click, I mean, that can read on just about anything. And if you're truly like enforcing that against people that you never intended, like against like innovations that were never intended to be claimed under that patent, then I can see why people sour against the patent system when they see bad actors, right?
Absolutely.
So
thinking about the founder's journey and how patents play a role in that, I'd be interested, from a startup focused perspective, Leif, what do you see as really the benefits for an early stage company of pursuing patents? What does a patent do for your organization in those earlier stages?
Yeah, so we thought a lot about this, and I want to just preface my remarks by noting that, this is our experience, and every company has their own potential innovations to protect. They have their own strategic goals. They have their own market. They have their own funding, stack. I mean, there's so many variables that go into why somebody would do patents. But for us, anyways, it really came down to thinking about the competitive landscape. So looking at the competitive landscape in our industry, do we get long-term competitive benefits from protecting certain things that we can do as a software company? And do we see that white space that we can protect? And, that was critical to us. I didn't a feature, I didn't want to patent a small thing. We wanted to identify that there was a unique new way of doing things that only software could allow to be done. And we found that white space, and I was like, that needs to be protected, because at some point somebody's also going to realize it, because we're going to talk about it. So timing is also critical. Like getting your patent in before you plan on going to market to talk about an idea is something that I think needs to be a consideration. And we wanted to make sure we started to protect that white space before the market was going to find out about it, which our competitors could start to try to figure it out as well. So that was of importance. So competitive risk or competitive advantage was definitely number one. Number two would be branding. And so as a small startup company, how you brand and market your company, and I know this wasn't one of the core areas that Jim mentioned for monetizing a patent, but for a startup it is, because you may be trying to raise money, and having a patent can help with your valuation or even getting a yes. If you're in med tech, hardware med tech, and you don't have a patent and you want to go on to phase 3 of clinical or something, you will get money, period, because they want to know that their money's going into a company that can have 20-year monopoly, right? So depending on your world, the branding and marketing around this is really important. So for us as a company, we brand and market in our industry as being very innovative. And so having patents pending feeds into that narrative that we're leading our industry into the new world. And so like that has value for sales, that has value for investor relations, it has value intrinsically to the company's brand. And to me, like, how do you monetize that? How do you value it? It's impossible, but it's real. I can tell you our customers and our prospective customers love the fact that they're with a company that's going to lead them, from the front. And look at Apple. I mean, they're known as an innovative brand, a lifestyle brand, but the innovation is strong, and they need to protect that. And so as a startup, creating that brand, I think, is important. Third reason that we did it was valuation. Purely getting into like one of those 4 that Jim mentioned earlier. We now have a valuation, third-party valuation completed on it with the support of Ideaship. And so now when I'm going to talk to investors and they say, well, we think your valuation should be $5 million. And I could say, well, we have patents on that you didn't value that are worth 2 million. So we want 7. Those conversations will happen when we raise money. And I'm just using random numbers, but you get the gist, right? Like there is a real value that our shareholders now have in the assets of that IP. That was third for us because as a startup, I think that one is the least interesting to us, primarily because, as a software company, we don't see the value of our patents being the number one thing that makes our company valuable. Like we're a business model play, we're a growth play, fast growth, go to market, technology's got to work, but like we're not going to win on patents. Some other companies might win on patents, and all of a sudden that valuation, it's like, well, no, instead of 10% or 20% of my valuation being patents, initially it's going to be a prerequisite to get any valuation. Then all of a sudden patents should run right up the pole, right? And so every company is a little different in how they have to analyze it and what their strategy is to protect it. But for us, it was timing, brand, competition and timing, brand, and then valuation were the 3 big things that really drove the decision. And, made it a really easy choice to make, especially with the support of Ideaship, knowing that coming out the other end of that, we would actually have the value that we were hoping to get versus trying to do it on our own. So I think that's a big piece of it, is that you could have all these reasons and strategies. Here's why I'm doing it. But if you don't pick the right attorney, you don't have the right team to make sure you're actually building the value that you're then looking to get out of it, then it's a complete waste of time, just like doing anything where you don't actually end up with the result you're looking for. So that was another key component of it, is that we had experts to help us through. And if I hadn't had that, I probably wouldn't have pulled the trigger either. So those are all things that were really important for us. Now that we've started to get into patents and, haven't filed, now we're starting to think about the next level of evolution of how we can monetize and ultimately ensure the most value out of our patents. And again, Ideaship and our counsel are doing a great job of helping us think through those things, timing of issues, how much we need to budget, which then goes into the fundraising stack, because we got to raise money or get it out of our customers. So you got to make sure you're budgeting for the ongoing costs of this stuff. So it's a different equation, but as a startup that did not have patents, it really came down to those three factors for us.
I think that third factor of valuation, I think also plays maybe a little bit against that perception that 95% of patents are not valuable, right? Because even if you're not going to enforce a patent, or even if you're not going to license that patent, it does still count as your valuation. And more often than not, you'll at least get your value back for that thing if you do decide to sell or just fundraise. I mean, having a patent or having 4 patents or 9 patents adds a lot of value, and it's more than just the 10,000 or 20,000 that you're spending on getting the patent. It's actually, I think that maybe says that maybe 95% of patents do have value, just maybe not enforcing value.
Yeah,
absolutely.
If we look at the valuation, and the group that did our valuation is a group called Global Technology Transfer Group. That was the third party that valued the patents that we had. They did 2 different methods. I won't bore you with what those methods are, how they work. They did 2 different methods, and based on the average of those 2 methods, we got a 50 to 75x return on our investment. So the valuation that they assigned to the innovations that they helped us, that we put together and protected, were worth 50 to 75 times more than we paid the patent lawyer to file them.
Wow.
And I'm using a range in there because I know we're going to spend more money to get these patents, further down the road and stuff. But, we're not talking 20%, 10%, 1x. I mean, we're talking, 50x. So it is a very substantial bump. Now we have to, actually realize that, because that's just paper now. But if we go to our next fundraise and I'm able to get an extra $1 million or $2 million on my valuation, like, holy moly, did I create some amazing shareholder value just in that one little piece, which I think is the third most important. So, kind of think about that. Like, the third most important piece of it may end up being worth 50x our investment.
You're years away from really monetizing on all of this time, energy, and resources that you put in. So, the question is how do we leverage this in the short term? And one thing that we at Ideaship really lean into is leveraging all that work from a fundraising and evaluation side, as you said, Leif. Like, ultimately, the optics of having a well-crafted IP narrative and a succinct strategy that is incorporating filing deadlines, ongoing costs, and how those will be handled with future fundraising. That all goes a long way for stirring up investor interest and giving you more negotiating power in these conversations when it comes to valuations for both investment and eventually acquisition. Now, as a technology company, obviously, IP plays a huge role in end acquisition. So I think, Leif, your point is that there's not really one value channel from patents. It's being able to leverage all the different benefits effectively so that you can really get your money's worth. I think that might segue well into thinking about what's important to consider for a founder when it comes to, okay, I've decided to pursue patent protection. What are some of the common pain points? What are some of the common pitfalls that we're seeing among startups who are pursuing patent protection?
Yeah, that's a good question, because the most common pain point is early disclosure of the invention. Because so in 2013, March of 2013, the US passed the America Invents Act, which was a huge change in patent law for the US, because prior to 2013, we used to be a first to invent system. So if an inventor invented something and then released it, they had up to a year to file a patent, and they could claim priority up to the date that they could prove that they invented it. And so in resolving conflicts between competing companies, whichever company could prove who invented it first won. But after 2013, we became a first to file system, which favors companies who have kind of MOs in place to file as early as possible. It was advertised as a victory for small businesses, but it was not, obviously. Like, big companies have procedures in place already, and little companies don't, because little companies are trying to get money. And then after they get money, they're like, I should file a patent, but sometimes it's too late at that point. And so I guess the pain point that I try to preach the gospel of to people is, before you commercially sell, before you publicly disclose your invention, try, if at all possible, to file for a patent. Because if you file for a patent before doing either of those two things, then you are fully entitled to all of the rights of a patent, including protection in the US, as well as protection elsewhere if you decide to nationalize in foreign countries. Now, if you've already disclosed your invention, whether it's being sold as a commercial product or in a non-beta type of situation, then you can still get protection in the US for up to a year, but you've kind of forfeited your right to go foreign in a lot of cases, because foreign countries are much less forgiving than the US if you've disclosed your invention before filing for a patent. So, I mean, that's the number one thing, is I try to get inventors and businesses to get a patent as early as possible, and before you disclose it to everyone. I mean, you can still disclose it to investors if you have a non-disclosure agreement. So there's still some control, like there's still a little bit of leeway there. But if you've commercially sold it, and if it's been more than a year, you're done. You can't get a patent on it. And you may as well just ride the wave and hope your company doesn't get too big, or continue innovating, which I think is probably the better option, is continue innovating and then get patent protection on your new innovations.
So one thing that I see quite often is early stage companies are interested in eventually pursuing patent protection, through an attorney, but they want to get something quick and dirty out there. They want to secure that early filing date. Yeah. So they spend $100 and they write their own provisional patent with the idea that they'll convert it into a non-provisional in the next year once fundings come through and they can actually bring an attorney on. And I generally advise against this, but Jim, I'd be interested to hear your perspective.
Yeah, no, that's a good question. I should have mentioned that too, because a lot of people read, how do I get a patent? And almost every article, every blog, every Reddit thread says, get a provisional. You can do that yourself. All you need to do is just file it with the patent office, pay a $50 filing fee, and you're good for a year. And your place is held and you're in good shape. But the problem is that when you decide to convert that provisional to a non-provisional, which is required if you want to have any patent rights at all, because a provisional patent, this quick and dirty provisional patent, it gives you no rights whatsoever other than a place, and it establishes that date that you invented your invention. And then you have up to a year from that point to convert it to a non-provisional. But the problem is that the non-provisional is restricted. You're married to that initial document. You cannot add any new matter. Like, you can't add new details. You can't add improvements. You can't add additional figures that teach new features or functionality. Like, you are limited by what you disclosed in that initial invention. And I would say more than 9 times out of 10, like maybe once in the last 10 years, have I seen a provisional patent that's good, right? Like, I honestly, unless it was drafted by a professional patent attorney and you paid at least $4,000 for it, it's probably worthless. Like, more often than, like, almost, like, honestly, Ian, I don't know, like you've been involved more in the investor side of things, but in my experience, I don't know that I've seen a provisional patent document that was drafted by an inventor that really was like enforceable in any way. Like, and if we did end up converting it to a non-provisional, it was just a number. Like it was just a pure valuation. It's like, maybe we can get a patent, probably not, but on the off chance we can, then you'll have one more patent to your portfolio, and there might be some value in that.
Yeah.
But like, as far as like a quality patent, I mean, you just got to find someone who has some experience, who's being honest with you about your rights. And I don't know, like that's a big pain point, is companies that try to do it on the cheap.
Absolutely. And, to that, an issue that I see is oftentimes we will be working with a company who has filed their own provisional patent, and ultimately we'd be in a better position had they not, because at this point, the material that they included in that original filing is to some extent off limits for potentially writing a fresh filing on that.
Yeah.
And ultimately, it's almost more work to sort of work around that original provisional than starting from scratch. So, I always advise, if you're going to go the provisional route, which I think there's a lot of merit to, in the sense that it gives you a year to raise more money, so you can, be able to pay that $10,000+ for a full application. And sure, while $4,000 isn't cheap, and ultimately it does add to the end cost, because not only do you have the provisional, but you later have to convert that, which is usually the same price as just filing a non-provisional right out the gate. While that does add to the cost, I think it's very well worth it from the perspective of, okay, if I see my technology really having long-term value and really being innovative, I don't want to cut a corner to save money when doing so, might undermine my ability to actually get protections on it later. So yeah, my general advice, and this is sort of my overarching advice to earlier stage companies who are considering patent protection, is don't rule anything out until you speak to an attorney. Again, a lot of people think that if they're in the software space, there's nothing to be done from a patent perspective. And while that may be true for your individual case, it may not be. And ultimately, the patent landscape is so complicated, and each type of technology has so many nuances as far as eligibility and requirements go, that you really need to have someone who has experience operating within that space. And, so again, my advice is always speak to an attorney, speak to someone who has experience in this. But yeah, so again, try to avoid filing your own provisional if you can. So another, sort of common question that I get is around trade secrets versus patents, and when each makes sense. And, we don't have a lot of time to cover this, but I'd be interested to hear your thoughts on that.
It's a good question. I mean, trade secrets. So I'm not super well versed in trade secrets, but I do know that if you have an idea and it's like an undetectable idea, or it's like the secret sauce of your algorithm, and you just don't want to disclose it to the public, then it might be worth pursuing trade secret protection. And what that is kind of a more internal contract-based approach, where you effectively like what I think Leaf mentioned, like early on in his development of his companies, he was more worried about assigning rights of the invention to the company and making sure that the company was protected in protecting the rights of the company. I think it's comparable to that, where trade secrets are just making sure that employees are under an obligation to not release confidential information. They can't go start a competing company that uses the same secret sauce, and you never have to disclose it. I mean, the most famous example of a trade secret is Coca-Cola's recipe. Could they have gotten a patent on that? Probably. Like if they had said, you know what, we want a 20-year monopoly on this formula, so that only only we can sell Coca-Cola for 20 years, they would have been allowed to do that. But the problem is that, they wanted it for longer than 20 years, and they felt confident enough that they could keep it a secret. And it would be really, really hard to detect if someone else was doing it. And so like kind of between those three things, detectability of your patent and like whether you can keep it a secret and whether like it's detectable, I guess, those are whether you want to keep it for more than 20 years, those are all considerations to take. And that's typically when I would say, this is kind of a trade secret type of deal. This is an algorithm. This is like an abstract idea that your company is while valuable and while innovative, may not be worth pursuing a patent on.
Yeah. So as a startup, especially if you're in tech, which most Newchip companies are, you should treat your entire technology as a trade secret. And so you should make your employees and any subcontractors that are going to have any insight into your tech stack, anybody who writes a line of code, anybody who is in AutoCAD or Metalworks or SolidWorks, that's helping design whatever it is you make, they should be locked down, like completely locked down. Everything they do should be assigned to the company. They should not be allowed to take it out, talk about it outside of the company, take it with them, compete against you. Like that should be just locked and loaded. And so like that's the first step of every tech company. If you do all of that and you don't talk about what it is that's going on under the hood publicly, you can patent later. You can always patent trade secrets anytime you want, as long as you haven't disclosed them publicly. So if Coca-Cola
sold it commercially,
right? Yep. So if you haven't broken through those barriers, you can still patent it if you want. So as you're starting up as a company, work with your early attorney that's hopefully setting you up with your company's organizations, and get him to refer you to somebody that has really strong employee and subcontractor agreements that you can get anybody who's you're talking to or anybody that's helping you with your invention, with your technology, to be, I call it locked up, to where they can't steal your idea, start another company, compete. We do that as part of our employment agreements, and we make all contractors do it. If you have a software developer that doesn't want to sign them and they're the most brilliant human being ever, tell them to pound sand and find somebody else. You'll find developers that are like, well, I can't assign you the rights to my work. I just don't do that. Well, you're the wrong one. You got to be just hard and fast, because if you have one hole in that armor, then basically it's going to sink to the bottom of the ocean. One hole in the boat and it's all for naught. So you got to be really, 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 really 100% on it. And so, I have one for everybody who's ever touched the software. Has signed one.
And you should do it for anyone you ever hire, right? From the very get, I think partnership agreements when you start the company, and then employee agreements as soon as you start hiring people. I think that's one of the first thing. Absolutely.
Yep. So that is like brand protection, IP protection. Everybody thinks patents. This is one other thing I wanted to make sure I got out on this. Think IP, don't think patents. Patents is part of an IP strategy. It is not the first place that most companies should go, I think. For most companies, I think patents is probably one of the last things they should pursue, because there's so many other things around your intellectual property that you can do that are a lot less expensive, a lot faster, and ultimately a lot better for a really early stage company. Patents come later unless you fit into like really defined boxes. Your strategy, your company type, like what you're trying to do requires patents. And there are companies that fit in that. So get good IP advice. But generally, I'd say, most companies can do a whole lot with a lot less money to protect their core IP and live to fight another day, to where they can afford to get the patents going in the right way. So like that's what we did, is we waited until we could do them right, instead of doing them sloppy and incomplete, or these other terms I could come up with that are maybe a little more colorful, and just do your best with what you can afford. And when the timing is right, you're going to learn more about your business, more about what you really are doing that's truly innovative in your industry versus what you might think is innovative when you start. And ultimately, that means your patents are going to be stronger. So, generally, I think that's good advice, especially for software companies, with a huge disclaimer that everybody else's is different. And there's certain cases where a patent might be the very first thing you want to do. And so it can be very different. But generally, I think, software, high-tech companies, there's a lot you can do that's a whole lot less expensive. Make sure you're doing the fundamentals and think about the patents as, the big hitter that you can bring to bear if it's the right time and the right strategy for your company. And Jim, maybe I'm wrong on some of that, but that's been the advice I've got.
I think that's good general advice. I mean, I think you should talk to an attorney early, especially like an employment attorney, right? Like it's not necessarily a patent attorney you need to talk to, but you can protect your IP in a lot of ways. And I think you're right. The first steps are not patents typically.
So that's all the time that we have today. Leif, Jim, thank you so much for taking the time to sit down and help educate all the viewers out there. Today we were able to discuss whether you need a patent or not as a founder, depending on your company and the technology that you're developing, what value that patent and that patent strategy can create for you, and what considerations you should be keeping in mind while you're on that journey of seeking patent protection, and how to actually execute effectively to ultimately get the end patent protection that you're looking for. Any parting comments, Leif or Jim?
No, I don't think so. I think we talked about a lot of good topics. I think that hopefully if people take anything away, it's to reach out and ask for help early on in the process. And there's a lot of people out there that are willing to help out to get you on the right path. So.
Yep, agreed. I think that's always been in startup life in general. You're as strong as your team. And so you should always be looking to expand your team to people that are experts and are willing to help you, make good decisions. You shouldn't expect a IP attorney to do a bunch of work for free for you, but you'll find people in your network that are attorneys, IP attorneys, or other startup founders that can share their experiences to help you better understand your world. And so continue to build that extended team. Newchip's great for that. Ideaship's a great resource. Attorneys are great resources. Advisors, grow your team. Focus on finding, folks that are going to give you good, candid feedback and advice on what you're thinking. And then ultimately, you got to trust that you've got the right strategy and the right focus for your company and execute it. So, lean on people for sure. Get a better team. Continue to reach out and ask for help, and do your best to be as educated as you can, and to the point where you feel comfortable and confident in the strategy and tactics you're pursuing.
Very wise words from both of you. And, thank you again so much for participating today. I would just, leave with that. Obviously, we're not able to cover everything. This is an incredibly complicated topic, but my door is always open. Again, Ideaship is a patent equity fund that helps early stage startups navigate their journey into patent protection and actually monetizing that work. So feel free to reach out and we can have a conversation. Thank you all for your time. You have a wonderful rest of your week. Bye-bye.
Awesome.